Richard Blok is a criminal defense attorney in, where else? Idaho, and he's back with me on the program. Richard, thanks for being here on this anniversary. Are you surprised that it has been a year and we still don't have a trial date?
Ashley, thanks for having me. I'm not surprised at all. I mean, a case like this, you would expect at least 2 or 3 years before it gets to trial, if not quite a bit more. It's an incredibly complicated case, lots of players, lots of different types of evidence. These things take forever. I mean, what people don't realize is that a lawyer who spends 15 minutes in a courtroom might spend 3 or 4 hours preparing for that 15 minutes. It takes a really long time to get ready for a multi-week trial. And when you're talking about a death penalty case, quadruple those times.
Right, four victims in this case. It is a quadruple murder, and some single murders or double murders can take, as we just reported, upwards of 5 or more years. So in this particular case, the defendant chose to waive his right to speedy trial. And, you know, I'm not sure everybody always understands why you would or wouldn't do that. Were you surprised he did it? And maybe give a little color as to what that means.
Not surprised at all about it. Frankly, it's pretty normal to see speedy trial waived or waived for a period of time to allow continuances and other things. From a defense point of view, like when I'm thinking about a case, in general, prosecution's case is best on the first day they filed it. And it can only get worse. Only then can the defense start poking holes in their evidence, looking for the flaws, digging up their own witnesses, digging up their own evidence, and building their own case. So for a defendant, you generally want as much time as you can get. Obviously, you're battling out between that, and especially when you've got a defendant sitting in jail, you don't want an innocent person sitting in jail when they don't need to be. So you want to move as quickly as you can reasonably do. But time is generally on the defense's side in these things. And even here, prosecution's still got to get ready for the case too. It's a tremendous amount of work to get all this stuff ready. I'm not surprised at all that he waived speedy trial to give himself some extra time to get ready, to dig up that evidence, dig up those witnesses.
Yeah, and the other thing is you don't want to get it wrong. You don't want an appellate decision to go the opposite way. You want to get it right. You want to have your I's and your T's all crossed and dotted and all the rest before you get into that courtroom. So the public defender in this case has fought the prosecutors on discovery, on DNA testing, on police training, on the grand jury process. Is this a good strategy, or do you see this as that's all she's got?
This is a damn good strategy. You want to fight on every one of these things because when you're talking about a death penalty case, you leave no stone unturned as a defense attorney. There is nowhere you don't go. There's no one you don't interview. There is nothing you don't do. There's no motion you don't file. You fight every little thing in a death penalty case because there's nothing worse. It's irreversible, the death penalty. So you fight every little thing. And here, where there's so much stuff to get out, like the DNA is one thing where it's obvious that there's tons of stuff that they're trying to look for because the DNA evidence here is very minute. And when you're looking at DNA, it's not the thing that everybody thinks where it's simply ones and zeros and it's yes or no. DNA is pretty complicated. There are different algorithms used to produce those results. There's different ways to interpret those results. And having all the information is really necessary so your DNA experts on the defense side can look at it and see if the other side got it right or if there is something wrong. So them going after all that DNA evidence, they're doing the right thing. They absolutely need that.
Got 10 seconds left. Do you have an over-under on when we'll see opening statements, and do you think we'll see opening statements or a plea deal?
I think you're looking for at least another year and a half until you're seeing opening statements. I couldn't begin to tell you if we're going to see opening statements or a plea deal in this. I'm not involved in the case, so I don't have the details of it. I imagine, but that a year and a half until we're going to trial, at least.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.